Hello and welcome to the SNIA Networking Storage Forum. We are presenting the Storage Security Series today. In particular, we're going to go deeper into the world of security and privacy regulations, which has been an increasing part of our current discussions. My name is Jay Metz, and I'm going to be your host and moderator for the webinar. I am the chair of SNIA's Board of Directors, and I'm going to be fielding your questions and providing the basic administrivia for this webinar. I, however, am not the geniuses behind the content, so you don't have to worry about me pretending to be a security expert. However, of all the webinars that we've been doing for the Storage Security Series, this is the one that I've been looking forward to the most personally. And this is where all of the theory is put into practice and where the teeth can actually bite. Misunderstanding this process and the requirements and all of the different components can mean some profound impacts on everyone's daily lives. Now, you probably noticed the increase of privacy pop-ups in your web browsers when you visit sites, especially in the past couple of years. And this is, of course, a result of GDPR, the General Data Protection Regulation. There is, of course, much more to GDPR than having a few pop-ups in your web browser. In some cases, the security and privacy regulations can have significant impact on your life, liberty, and financial well-being. And that's what we're here today to discuss. As part of this Storage Security Series and the important parts of security and privacy regulations that affect you that you may not even know about. Now, as a start, I need to introduce you to a few key points concerning the BrightTalk interface. And then I'm going to introduce our honored speakers. If you've not attended a BrightTalk webinar before, this may seem a little bit confusing, but there are a couple things that you might be interested to know. First, you can expand the screen size. This may be important if there are any details during the presentation that may appear difficult to read simply by enlarging the screen to the full screen mode. Second, you can download this presentation right now. As a matter of fact, yes, it's available, and yes, it's available right now by choosing the option on your screen under Attachments and Links. It's available in PDF format. Go do it. Do it now. Third, you can ask questions during the presentation by selecting the Ask Question option and entering your question. It's pretty intuitive. So we will have time at the end of the presentation to answer these, and in fact, we'll probably be answering many of them during the presentation as well. Finally, and this is extremely important, you can rate the presentation. This is important to us because it gives us a solid indication of whether or not we're delivering the right quality of content in the right fashion and at the right level. So please rate the presentation at the end. A score of 1 means you probably rather have spent the time gouging your eyes out with a grapefruit spoon. But a score of 5 is going to mean that it was absolutely perfect. We're obviously going to strive for the number 5. You can also send us your comments and your feedback on our webcast program and let us know if we're covering the topics that you want to hear about. So having all said that, please allow me to introduce today's speakers, Thomas Rivera and Eric Hibbard, two influential security professionals with over 10,000 years of experience between them, or at least it must feel that way. Joking aside, the contributions of these two gentlemen have made to IT security is certainly a lot better than my pronunciation of the word, but it is extensive and as well immeasurable. So, hello, gentlemen.
Hello.
Hello, Jay. Hey,
excellent.
Thanks for the opportunity today.
Trust me, it's something I've been looking forward to. So before we get started, let me get into the standard legal disclaimer from SNIA. This is just to remind you that the material is copyright by SNIA and to detail the conditions under which the material can be used. Also, it's to state that SNIA is not providing any legal advice here, and we're not providing any warranties, expressed or implied, in the content of this presentation. You can use this material, and the use of this material is at your own risk. Ooh, sounds really, really ominous. So if you're not familiar with SNIA, let me give you a quick overview. SNIA is a worldwide organization that's involved in the creation, administration, and education of all things storage. We do so specifically with a vendor-neutral status, and we work to develop industry-wide standards. And to that, we enlist the help of subject matter experts in our membership community such as Thomas and Eric, and then we provide some of the marketing and promotional programs to help in that adoption. But as I said, we cover all things storage, and this is just an abbreviated list of some of the things that we've been working on. We have a large number of current projects that haven't quite yet made this list, but are no less significant nevertheless. So our educational materials may take many forms, including webinars like this. We also have a standardized industry-wide SNIA dictionary to help codify some of the storage terms, and you'll see our presence at many industry events, virtual or face-to-face, giving talks on a variety of technology subjects. Now, having said all that, it's time for me to get out of the spotlight and get to the good stuff. So this presentation is going to be slightly different than what you may be used to if you've been attending some of these, because we're going to be joining in a panel conversation towards the latter part of the presentation to discuss some of the key issues that are currently plaguing regulations and affecting the understanding of those regulations. So, Thomas, I believe I am passing this off to you. Is that correct?
No, actually, off to Eric. Thanks, Jay.
Oh, my bad.
No worries. So, thanks, Jay, for that warm up and get us going here. So what we're going to try to cover in probably a bit of a whirlwind fashion. None of you will qualify for certification after this, and of course we won't test you on any acronyms, which is sort of part and parcel with a lot of the material that we deal with here. So ideally, we would like to give you some understanding of some general characterization of both privacy and security, how they align, how they're different. In fact, if you walk away with an understanding of how they're different, we probably had some measure of success here. We're also going to talk a bit about data retention and deletion requirements, and this is in some ways going to be an example of how some of the security requirements sort of materialize, and there's interrelationships with various standards and whatnot. We're going to talk about core data protection requirements, and we're use some sample privacy regulations. Some of that is globally, although we're going to key off some California regulations, but California thinks it's a country on its own. I know, I live there. The role that security plays in key privacy regulations, and then we'll delve in some of the implications and consequences, which can actually be fairly important. All right, so I'm going to walk us through the security and privacy characterization piece first, and this is where hang on to your hat, and if you're thinking about a CISSP, this will give you an idea of what you need. CISSP is one of the security certifications. All right, so I'm going to start with the threat landscape for security, and this is, if you're a practicing security professional, these are all the kinds of things that keep you up at night, or if you ever get to sleep. They are in sort of a loose order of their prevalence. So you see social engineering, and I guess this is probably where I should make the comment. The weak link from security tends to be the people involved, not the security professionals, but it's the human element tends to be the weakest link, and so social engineering plays in very heavily into that. The advanced persistent threat element is something that really gives security professionals a lot of concern, because these are the things they don't necessarily know about, and you may have malfeasant behavior sort of lurking in your infrastructure for extended periods of time. I'm sure many of you have heard of ransomware or malware. Malware is sort of your viruses. Ransomware is actually turning into a bit of a lucrative business for the bad guys, so to speak. Next one is unpatched and unupdated systems. This actually is a source of a huge amount of problems on your personal computers as well as enterprise class systems. Failure to stay on top of this stuff is a source of many breaches that basically occur. Denial of service and distributed denial of service, we're seeing this continue. What's intriguing is the kinds of devices that are performing it. It used to be, enterprise class servers were being taken over. Then it moved down to PCs, and now we're actually seeing little things like cameras participating in these kinds of attacks. Concerns about misconfigurations. For example, you may have antivirus software running, but if it's actually not pulling down signature files, in other words, it's up to date, it may actually not be all that helpful. Lots of concerns about sensitive data exposure, aka data breaches, injection flaws. These often come into place in sort of web-based interfaces or databases that end up leaking information or could be an indirect path into taking over a system. Cryptojacking, basically your PC or system is taken over to essentially mine cryptocurrency. Somebody's making money off of your systems, basically. Cyber physical attacks, this is typically involving critical infrastructure. We're seeing broken authentication, broken access control, somewhat self-defined. Third parties, supply chain security is a big source of concerns when we've had a lot of data breaches that have basically occurred because somebody working on an HVAC had access to a system that was the source of an attack. Of course, there's the ever popular insider threat. In the last few years, with all the smartphones, we're now seeing mobile malware, and we anticipate this is just gonna get worse and worse and worse. There's physical loss of devices, or in some cases, it's been stolen. And then cross-site scripting, which has been around for a long time from a web perspective. Man-in-the-middle attacks, where if you're using weak forms of like TLS, transport layer security, you could actually have somebody that's seeing everything that you're doing. And then last but not least, weaponized IoT, and this is sort of back to that sort of camera situation I mentioned a minute or two ago. So these are all the kinds of things, and there's many, many more, but these are some of the top ones that we tend to worry about. This is where we're seeing attacks and problems, incidents, breaches from these and combinations of these items. All right, so I'm going to switch to talk about the privacy landscape, and the goal here is so that you see that there actually is a difference. So in this one, you see information collection. So you get surveillance, which is you're essentially observing or capturing individual activities. Interrogation, so you're questioning individuals, otherwise probing for information. Under information processing, there are techniques for aggregating up data, which may give more information than you as an individual might, for example, want somebody to know. The next one is identification, which is connecting information that an organization might have to a particular individual. Insecurity is sort of kind of obvious what it is. Secondary use is you thought you were giving data for maybe your hospital records, but then they're selling it to a drug company, and you're probably not going to be happy about that. And then exclusion is basically denies an individual's knowledge or participation in what is being done about his or her information. So you're not being clued into how your information is being exploited. Under information dissemination, you have breach of confidentiality. You have disclosures, which involves revealing the truthful information about an individual that maybe negatively affects them. Distortion, spreading false, inaccurate information. We've never seen this kind of behavior, right? Exposure, which results from revelation of information that we normally conceal from others. Maybe you've got a disability or an illness or something you just don't want out in the wild, so to speak. Increased accessibility, again, making some information more readily available than you want. This is an area for children, in fact, is a big problem. Blackmail, again, this is a self sort of described kind of problem we know about. An appropriation is basically using someone else's identity, so identity kind of theft, if you will. And then the last two, intrusion and decisional interference. Intrusion is basically intruding into somebody's individual solitude or tranquility, like any of us have that, right? And then decisional interference, inserting themselves into a decision-making process that may affect you, and in particular in a negative way. So from a privacy perspective, the goal here is to give you an idea that privacy is not security. There is a security element in this, but these are the kind of things from a privacy professional that you're worrying about. Okay, so the other aspect that's important to understand is, and this is more focused on the security piece, is there's a balance that's struck between achieving true security versus compliance. And from a security perspective, it tends to be focused on things like proactive behavior, defense in depth, and you're dealing with physical, technical, and administrative controls, the preventive, detective, and corrective kinds of controls. Those are the kinds of things that security people are usually involved with. On the compliance side, it tends to be reactive. You're worried about accountability, who did what, traceability. Do you have evidence that you can show, who did what? Monitoring, reporting. A lot of the regulation basically has a reporting element. And increasingly, we're seeing risk management come into play. It's often the compliance side that drives what's happening in the security space, because the regulations will, in some cases, have some teeth. If you don't do this, you're denied access. If you don't do this, there could be legal implications. If you don't do this, there could be fines. From a security perspective, I know this is a bit of an eye chart, but it was intended to be. This is basically the structure of ISO 27001. This is one of several security frameworks that security professionals tend to use if you're in a larger organization and they have a security policy. Most likely it's based on that. If you're in the US government, then you'll have something equivalent to it, which would be the NIST Special Publication 800-53. Similar organization. And the point of this is that these are the major elements, and then there are a whole bunch of controls under each one of these, and each and every one of these has to be looked at from an organizational standpoint. And these have been documented because of past problems. If somebody makes comments about best practices or reasonable security, you should be thinking something on the order of, oh, I guess that probably means something like 27001, because it is in a standard, right? So there's one in here that's under asset management, and I bring that to your attention because underneath asset management, there's an element for media handling. So what do we mean by media handling? Well, that's basically managing removable media, disposable of media, and physical media transfers. Basically, the idea is you want to make sure that if there's any sensitive data that's sitting on storage media, that that data is eliminated before you essentially lose control of that media for whatever reason. And then there are other standards that will pick up. So how do you do that, or what degree do you have to do that? For example, there's the 27040 standard, which is storage security, which obviously we in SNIA are very interested in. It actually talks about media and data standardization. So basically how to make data go away. There's different options that for clear, purge, and destroy. You may have heard of, well, I can get rid of things by using encryption and destroying the key. Something that nature is called cryptographic erase. which would be a purge mechanism. And the standard does go into very technology-specific kinds of things, including paper, because paper is considered a form of media. Okay, so moving a little more back into privacy versus data protection, this is an interesting discussion, a lot I have to deal with on a regular basis because of some of the standards work I do, especially representing US. In many countries, the focus is on dealing with personal data, which is data about individuals that organizations collect, store, use, and disclose. Data protection is definitely the term that the EU uses. The US, probably the equivalent to that is information privacy, and you'll see that there are actually many forms of privacy. It's, again, as we said earlier, data protection is not the same as data security. There is a relationship. We'll try and show you what that looks like, but it's important to keep that in mind. So I mentioned that there are a bunch of different areas in privacy. So information privacy is the one that in the US that we often talk about, and probably the one that's probably most closely aligned with something in the European General Data Protection Regulation, or GDPR. So it's focused on the claim of individuals, groups, or institutions, and how and extent information about them is communicated to others. But there's other forms. So there's bodily privacy. So your personal space, so to speak. There's territorial privacy, and so there's potential limitations, intruding into one's environment, and there's communication privacy. So things like correspondence, postal mail, telephone conversations, and so in the broader sense, all of these components make up sort of the more general area of privacy. Many times when you're talking about privacy in sort of the IT space, it is focused just on the information privacy piece. Okay, so there have been for quite some time common privacy principles, and these are basically items. So collection limitation principle, there should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means. Data quality principles, so this is, the personal data should be relevant to the purpose that it's being used and to the extent necessary for that purpose, and it should be accurate. Purpose-specific principle, again, this is the data collected should be specified not later than at the time of the data collection, and the subsequent use limited to the fulfillment of those purposes or such others. Do you like this? Sounds very legal, right? So it's really focused on why you are collecting the information. Use limitation, the personal data shouldn't be disclosed or made available or otherwise used for purposes other than what was required and specified. Secure safeguards principle, personal data should be protected by reasonable security. I love reasonable security. You'll see us go off on that in a little bit. Openness principle, there should be a general policy of openness about developments, practices, and policies with respect to personal data. Individual participation principle, so you have the right to obtain from a data controller or otherwise confirm. So basically, you should be able to find out what they're collecting, why they're collecting, what have they collected, and potentially make that go away. And last but not least is accountability principles. The data controller should be accountable for complying with measures. So this is kind of a sweeper clause, but if you're a data controller, if you don't have some of the mechanisms in place to respond to people that you're collecting information on, you could be in serious trouble based on some of the regulations that exist. Okay, so what we've attempted to do here is try to show you sort of how many of these things come together. So the outer ring is basically ethics, think of that as, what you should or shouldn't be doing, sort of a moral kind of thing. And then you see on the left-hand side, privacy, which are dealing with some of those principles that I just went through. On the right-hand side, you see information security, which is focused on confidentiality, integrity, and availability. And there is some overlap between those two. And then in the midst of that overlap, you'll see personal data protection, and you'll see cybersecurity. And so those of us that operate in both the security and privacy world, which I definitely do, there's an area where we have to have an understanding of all of these areas, monitor what's happening in the standard space, and understand some of the interdependencies that in fact exist. And we'll, during the panel, bring this slide up again, because I've got a feeling that this may actually be useful to discuss. Okay, so privacy and security, to sort of bring it to a summary, what is privacy? Well, in some parts of the world, it is an element of your basic rights. In fact, I'm fond of saying that in Europe, the Europeans treat privacy like Texans treat gun rights, and that's no slander on Texas. It is they are that vigorous in terms of protecting that right. Privacy is realized through legal means, so it's not technology. It's usually codified in laws and constitutions and things of that nature. And data protection is what deals with the technical framework of that. So hopefully that kind of sort of ties some of that together. All right, so security, and this is from a data or information security perspective. It's the measures or controls to guard against the loss of unauthorized information, destruction, use, modification, and disclosure of data. As I mentioned earlier, confidentiality, integrity, and availability are the core elements. There are different models that can expand that out. There might be 9 or 10 of these sort of core elements, but in general, these three are always recognized as core. And there are lots of frameworks. We talked a little bit about 27001 and the NIST, but there are many others that exist. And the good news is there are crosswalks between those. So you choose your framework that you want to use as a basis, and if you encounter another one that you potentially have to worry about, there are ways to move back and forth between them. Last but not least, privacy is dependent on security. Security is not dependent on privacy, and that's an important thing to keep in mind. In other words, you can have the best security people in the world and have absolutely all kinds of problems on the privacy front. On the other hand, if your privacy people are not looking at the security, they're screwed as well. All right, so with that, we're going to move to the data protection regulation sampler, and I'm going to turn it over to Thomas for this.
Well, thank you, Eric. Nice overview. Thanks for the summary there. So in terms of the sampler, we decided to really talk about a couple of different regulations because there are actually many globally. But before we do that, it's probably important to set the common baseline of, well, what do we mean when we say things like PII, or personally identifiable information? So from a definitions perspective, and this is actually from ISO 29100, is basically it's any information that can identify directly or link directly to a given person. I'm not going to read all the entire definition, but in a nutshell, that's really what it is PII is anything that can link back to a given person. The interesting thing about this and sort of how it relates is, for example, and this is the example at the bottom of the screen, kind of interesting, especially as it relates to nowadays, because we have things like GDPR, which we'll talk about a little bit later. A given IP address on your computer, just as an example, is typically not classified as personally identifiable information, or PII, on its own, but typically it's classified as linked PII, meaning it can link back to you with additional information. But with regulations such as GDPR, the IP address of a given person actually may be classified as personal data. So that's an interesting point, because now you have companies, and you may have noticed this if you're reading articles and reading what's going on globally, you're noticing some interesting areas where there's a lot of concern about companies keeping personal information. And there's a lot of talk about not just your name and date of birth and some other related things that can link you as an individual to the information, but even as far as IP address of your computer, for God's sakes. And a lot of people are wondering, well, why is that? Why would you even bring that up? And that goes back to one of the regulations out there. Actually, it actually makes a difference, and that regulation happens to be GDPR. So just as an example, so some of the sample regulations that we'll talk about from a privacy perspective, and again, there's many, but we decided to focus on a few. The first one is GDPR that we already discussed and actually brought up. And in a nutshell, it's actually a fairly large regulation, but in a nutshell, what's mandated by GDPR from a privacy perspective is how do you handle the data of the citizens of European Union, and that's a very specific group of people, basically about 26 countries in Europe that make up the EU or the European Union, and you are basically mandated to safeguard that information as that data gets processed or moved, if you will, through multiple environments. And we'll talk a little bit more about GDPR and some of the main sections of it in a minute. The next one that we'll talk about a little bit is about the CCPA, or the California Consumer Protection Act. And that actually just went into effect at the beginning of this year, 2020. And it provides some enhanced rights from a privacy perspective as it relates to residents of the state of California. Interestingly enough, that doesn't mean that it's only companies in California. It means if you are a for-profit company doing business with California residents, you are affected by the CCPA. And oddly enough, that actually means a whole bunch of companies, not just those that are residents of or residing in or headquartered in the state of California. Lastly, the IoT law in California. Sometimes you may hear it bantered about as SB 327, but it's still commonly referred to as the California IoT law. That also just went into effect January of this year, and that from a privacy perspective goes into regulating IoT connected devices. So we'll talk a little bit about each of these as we move forward in these slides. So to start off, how do we describe data protection? Well, and Eric talked a little bit about data protection generally. Well, in the EU, data protection is defined as protecting information relating to any of the people. In the regulation itself, they'll talk about data subjects, but basically any actual person living in the European Union, and that information could include names, date of birth, photographs, video footage, things like email addresses, telephone numbers, and the list actually goes on. But that would be what we're talking about, is actually protecting that data relating to any given individual. In this case, any individual that's a resident of the EU. And then how that data gets processed, how you collect it, how you use it, how you store it, for both public and private sectors. So it's pretty broad, and that's why it holds quite a bit of weight. Also affects many companies globally, not just because it's some of the teeth involved with the penalties and fines and so on, but also just the fact that as if you're dealing with data that has to do with residents of the EU, by definition you are affected whether you like it or not. So that means many companies that are global companies that are dealing with the residents of the EU and their respective data. So from a regulation perspective, it allows the people or the residents of the EU to have rights over that data. In other words, they get to decide what you do with their data. So you have to have a whole bunch of things included to give them things like the ability to opt out, and they can do things like, hey, I want you to delete my data, which commonly referred to as the right to be forgotten. Just a few examples. We'll actually go through a few more examples on the next slide. And then just to let you know, it was adopted back about 4 years ago and then enacted into law 2 years ago. So from a PII perspective and how it relates to GDPR as a regulation, some of the things that are requirements within GDPR as it relates to personally identifiable information are these sub-bullets that you see on this slide. So things like the ability to require consent for processing of that data. There are anonymization clauses in there that allow you that force you to do anonymization of the collected data. There's some interesting verbiage on how notifications have to be done in the case of a data breach. Those are quite specific, and by the way, they do have some teeth to them, so that if you do not comply with the notification regulations for a specific data breach, then there are some penalties that kick in, and these penalties are actually pretty substantial, and for a given organization, they could mean that you potentially could go out of business. That's just based on how damaging they can be from a financial perspective. Another one is the ability to forcing companies to appoint what's called a DPO, or a data protection officer, to oversee the compliance of GDPR as a regulation within your company. There are certain rules and regulations as it relates to a DPO. In other words, not every company has to have a DPO, but if you're of a specific size, you do have to. And we're finding that many of the smaller companies that don't necessarily fit into that size minimum, they're basically assigning a data protection officer anyway, just because they don't want to get fined later on for something they may have not have seen or necessarily planned for ahead of time. And the last one is a one that's commonly in the news, and that is the right to be forgotten. In other words, you can wake up one morning and decide, I don't really want that data, that my personal information out there on that particular application, website, hosting site, whatever the case may be, and you have the ability through the regulation to actually request that your data be erased. So this is actually a pretty, as you can imagine, in looking through that list, it's pretty all-encompassing and covers quite a bit of ground from a regulation perspective. The next one that we wanted to cover briefly is just the CCPA, the California Consumer Protection Act, and as it relates to personal information, the main issues or the main things that it covers are things like how can you collect, sell, and disclose that information. It has to provide access to the consumer to that data. So in other words, you have to be able to have access to it and then go back and say, hey, thanks, but we've decided to then opt out and take that or have them remove that data. Again, this is personal information of California residents, and it doesn't matter if your company is outside of the state of California, so as long as you're dealing with information of, or personal information of California residents. And then last one is that we'll touch on briefly is the California IoT law. I won't read this slide to you, but basically it's any time that a device is connected, and that's either a protocol, be it an IP address, an IP or a Bluetooth address is assigned to a device, regardless of what the device is, be it a camera, a watch, and the list goes on, of course, that is affected by this law. And the interesting thing here about this law is that it uses this term, which I mentioned at the very, very bottom of the slide, is reasonable security. Well, that's pretty vague, and it was purposely written to be vague for legal reasons, but it's very difficult to abide by a regulation when it's deemed to be, hey, make sure you're using reasonable security, because that's up to interpretation. And then the last one that we'll talk briefly about is the Lot 9, and this is a European regulation. It actually has to do with doing some regulations on how you can do design requirements for energy consumption of, in this case, data storage products. Well, sort of a side shoot of this, and I don't think it was necessarily originally written to affect this, but one of the side effects was that in one of the stipulations in the Lot 9 regulation specifically is this, what they term, and this is the fourth bullet here, what they term secure data deletion. So what the idea is, hey, make sure that you erase that data on that media, whatever the media is in the storage device, so that you can then, from an eco perspective, reuse it. And that's the whole idea of this eco design requirement for energy-related consumption. Well, the problem is there are certain types of media that there is no such thing as securely deleting the data, because in some cases things like special types of RAM, for example, NVRAM and NVRAM disks, there is the ability to do maybe potentially an erase command, but that doesn't necessarily, because of the virtual nature of that type of media, doesn't necessarily erase the data at all. It just maybe deletes some pointers to it. But in essence, the end result could be that you still have data on that device, and that could actually result in a data breach because you technically didn't remove that data. So it's not really explicit and adequate, and it could actually cause some serious problems as a side effect of this particular regulation. Some of the security failures at a high level, what are the implications from a security perspective? Things like ransomware, you could have data breaches, some contractual obligations that haven't been fulfilled. A big one today is supply chain insecurity, things like counterfeits and disruptions. And what are those consequences of these specific implications of poor security? Those consequences are many, but we list a few here, things like liabilities, incident response costs, legal issues, business disruption, which actually could lead to a loss of reputation and damage to your company and your systems. So at a high level, the summary really is that these regulations that focus on risk are really sort of future-proof, and GDPR would be the example here. Is you notice it's actually quite future-proofed in that they're really focusing on risk and how you design towards risk. And the next one being the privacy protection requirements. Those actually will often change based on your priorities from a security perspective. And then in terms of Lot 9, as an example, requirements can be introduced that's not necessarily directly related to the regulation in and of itself. Like it's a regulation on eco-design of a system so that you can reuse the system, but it causes another problem in another area, and that would be in the case of a secure data deletion where you could end up doing a data breach when you didn't really mean to. So again, some of the summary aspects are those. Eric did go through this graphic earlier, which we might point to during our discussion. But the key takeaways here are, which Eric mentioned earlier, privacy is dependent upon security, but security isn't dependent on privacy. Jurisdictional variance can be significant for privacy. In other words, where the regulation actually resides. Some of the imprecise language in the regulations, we've given you a few examples here. It can certainly complicate compliance and in some cases really undermine the original objective of the regulation itself. And then lastly, some of the indiscretions from a data perspective as it relates to personal data. It gets more coverage in certain regulations than other types of data, things like intellectual property, just as one example. So I'll turn it back to Jay for a panel discussion at this point.
Great, thank you very much, and thank you both for trying to cram in as much of this information as you possibly could in 45 minutes. It doesn't leave us a lot of time to go into some of the broad consequences of this, so I'm going to do my best. There's a lot of stuff to talk about. We got a couple of questions, a few questions that came in, and I highly recommend that people who are on the call to throw in the questions. Even if we can't get to them now, we will do a Q&A blog afterwards and post that. So get your questions in, and we'll address them as we can. Obviously, it's impossible to talk about these sorts of things without getting into the political ramifications and oftentimes civics. So one of the things that I'm just going to go ahead and start off with one of the questions that came in, and we can go from there. So do you see the U.S., especially in light of the changes between the way that the U.S. handles privacy compared to the EU, but do you see the U.S. working towards a national policy around privacy, or is it going to stay state-specific? And I'm going to expand the question a little bit and say, okay, in light of the differences between what happens in the EU and the requirement differences, what are the impacts of that, of the state-by-state policy and how that impacts on the global stage? So who wants to go first?
I can take that, Jay. This is Eric. And I do some work within the American Bar Association, in particular on the Cybersecurity Legal Task Force. So this is an area that we are actively tracking. I think, as probably some of the audience is aware, the whole privacy shield just came crashing down. So that's I think going to have an impact on some of the future directions, but frankly, given the current focus in Congress, don't expect to see anything significant in terms of privacy regulations for a while. There have been multiple attempts over the last several years, and none of them have cleared both houses of Congress. California, which we talked about earlier, has essentially done what I call GDPR light. It's not the only state that's dabbling in this space, but there are several other states that are looking at what California has done. And by the way, California is not done tweaking what it's done. It's amended it multiple times, and I think we're in the process of doing it yet again. So it's a bit of a work in progress. But it's been said that the way California goes on some of these regulations, the rest of the country eventually follows. And so it's reasonable to expect that what you're seeing in California is likely to show up in a bunch of other states. From a federal perspective, I think it's going to be a while That's the depressing news. The good news is that some recent things like Privacy Shield has gotten the attention of Congress, and so it's kind of back on the table, but it is a bit of a back burner topic.
Okay, so that's a really good point to try to take a quick pause. In 30 seconds or 45 seconds, can you summarize the Privacy Shield question and controversy?
Well, so the idea behind it was that there were some principles that you would subscribe to, and if you failed to do that, on the U.S. side, then you could potentially, your organization could basically run into some trouble. And from a U.S. perspective, Department of Commerce had put this forward to the EU, saying, look, this is our privacy regime, to deal with your GDPR. And what's happened is that the courts in the EU said not adequate. And so that structure, and there were a fairly large number of companies that were subscribing to the Privacy Shield principles. What that now means is they've got to step back and they have to have binding contractual clauses, basically, in their contracts that deal with GDPR. And many companies, for example, not to pick on Microsoft, but Microsoft had sort of a two-pronged approach, and they were dealing with Privacy Shield as well as having these contractual clauses. So in their case, it was pretty much a non-event. But other organizations, the whole focus was, we're part of Privacy Shield, therefore we've taken care of what we need to do for Europe. And now it's in trouble.
Well, that's part of the problem, isn't it? I mean, you've already brought up the idea of the California IoT law going through yet another revision. And there's just so many moving targets here with the conversation about GDPR having some significant teeth, with all these quote unquote players to be named later or rules to be named later. I mean, how is it best to approach this? Because you can't pin Jello to a wall. It gets confusing.
Yep. I use a slightly different analogy. It's putting tape on an eel, but it's the same kind of problem. So as both a practicing security and privacy professional, it means I literally have to watch the regulations around the world, and it includes countries like Russia and China, which actually have some interesting privacy regulations that have gone into effect, in the last 2 years. But what we've seen is Europe with GDPR essentially leapfrogged what was happening in Singapore and Australia, New Zealand, and it would not surprise me to see those countries tightening up their requirements as well. But if you're a multinational or dealing with multinational kind of scenarios, you got to watch the world space. And then the U.S., and we've got a similar problem with security, because we're seeing a state by state, dealing with this reasonable security kind of stuff is getting very complicated, very ugly.
So this raises a difficult. Yeah, I was just going to say, Jay, that
go ahead, Thomas.
It just makes it more difficult too, is to understand that at the federal level in the U.S., and back to one of your original questions, Jay, is, why don't we have something at the federal level like other countries do? And it's important to note that it's highly opinionated from the corporate side. There's a lot of lobbying going on. As you can imagine, there's many large corporations in the U.S. that have no desire to have privacy regulated at the federal level. I'll leave it at that, because you can imagine the reasons why.
No.
That's an important point.
Yeah, that's the elephant in the room, and let's at least point at the elephant. So, likely to happen if there's a federal privacy statute that has any sort of teeth in it, it's probably going to be preemptive, and and it's probably going to try to preempt what happens in California or Massachusetts or a few other states that have actually enacted laws that are protecting its citizens. And so that's, I'm not sure I would really be strongly advocating that we go for a federal privacy law until maybe some of the states have sort of demonstrated what's really sort of best here, because you could actually see some protections being decimated with a poorly written federal law. It's not that we've ever seen poorly written federal laws in the past.
Yeah, and there's just so many things. I mean, because we talk about the California law and the IoT law. One of the questions came in actually really quickly. We unfortunately are pushing our time limit. So Thomas, could you quickly summarize the IoT law? I know we've got the attachment in the link below. They can actually get a little bit more information, but does it force IoT manufacturers to continually support IoT devices with security patches through its lifetime?
It's one of the areas that is currently, the answer is yes, and then I think there's some wording that the state of California is trying to change. Eric, you probably have the more up-to-date information on that.
Yeah, it's it has some explicit pieces that talk about authentication. For example, if you've got a password, there's some language in the password's got to be unique for the device, every device made, or the first time you log into it, you got to change it. But then from there, it lays out some sort of principles. They all come down to basically trying to quantify in an abstract way reasonable security, and that's the problem is that that's being complained about, and patching and updating is part of, as you saw earlier on in some of the materials I was presenting. That's assumed to be part of sort of normal security practices. Well, if you look at a lot of IoT devices, many of them were one and done, and in fact it may not have any security in it at all. So this is an area that's a bit problematic, and the other piece of it is only the Attorney General of California can actually sort of bring an action. So this is not that there's no right of action to California citizens. So it sort of depends on whether you've done something as a vendor very egregious that's caught the Attorney General's attention, and if you have, then look out.
Well, you just raised the whole specter of a number of different things, including remediation. What are the actual rights in terms of how they're misunderstood, like the right to be forgotten. How do the governments regulate themselves? All of these different things. Unfortunately, we don't have time for. We're going to have to put these and some of the other questions that came in from the audience into our Q&A. So, me. We could talk about this for another hour at a minimum. Sadly, we just don't have that kind of time. So, I'm going to have to push us forward just a bit to keep us on track. One of the questions that did come in, a really good one, by the way, on the future of encryption, particularly about how different acts in the regulations are being applied to encryption. Next security webcast we have is about applied cryptography, which I don't believe is going to cover that question explicitly, though we will see if we can actually add it in. But that is going to touch about how cryptography works at the applied level, not just the philosophy behind it, because we already did key management. So I highly recommend that you take a look at that and register. The other thing to keep in mind is we've got a lot of these different things. This is a series, and if you haven't seen the previous versions, the idea is to give you a holistic view, all the way from the social level down to the bits and bytes, from the data on all the way from your phone through the cloud to the actual storage devices. So there's a lot of information here, as you can see just from today. It's not as simple as doing a simple one webinar and being done with it. But you can follow us on SNIA NSF on Twitter, where we post all the dates and times for those upcoming webinars. We also have some additional links about the SNIA resources themselves, including some of the work that Eric and Thomas are doing inside of the organization. And to that end, I highly recommend that you take a look at that. It's, of course, all the links are in the PDF that you can download right now. So please, please, please rate this webinar. Please provide us with some feedback. You know, simply saying, this webinar sucks, doesn't actually help us. So a little bit of constructive comments, feedback is really welcome. We also have the availability of the slides on our website in the educational library, as well as right here in the attachments and links right now. And of course, we will be posting a Q&A for all the fantastic questions that have come in. Thank you so much for your time. Gentlemen, really honored to share the stage with you. Thank you so much for doing this in a very brief time period. Thank you so much.
Thank you, Jay.
Thanks, Jay.
All right. All right. Take care, folks, and have a great day.